Is it logical to have an inquiry with such narrow terms of reference that it will exclude key elements and evidence and references to the wider, broader picture of systemic failings in the health service, in particular neonatal and even maternity? We've had so many other reports showing evidence of preventable, avoidable deaths and serious injuries to mothers and babies, Ockenden, Francis, Kirkup, and these reports are not acted upon. Now we have this inquiry and it will have some findings. There will be some evidence coming out throughout the process that show concerns and things that could be acted on and changed. But there's very little impetus from government, from the state, from legislation. In particular, the judiciary are often seen as the good guy, always, the white knight in shining armour, that they get things right. We know of many miscarriages of justice, wrongful convictions, and the UK has this blood scandal, the post office scandal. It has general scandal about healthcare and in particular maternity and neonatal, as in there's obvious problems and not very much being addressed to solutions and fixing it. People like myself, I've worked over 40 years in neonatal and maternity. I work in law and legal cases. We are offering information and sometimes evidence to NHS England, to state bodies, to Parliament, to ministers like West Streeting, and we just get the political pushback of don't look here, nothing to see, and they're making assumptions. They want to carry on, protect their reputations individually, whether that's individual ministers or judiciary or other state players. Even Lady Thirwell is going to have a protectionist role, and that's not helpful because the statements that she's made about people commenting on the case is also not helpful, not accurate, not true. So I come back to my opening point. Is it logical to have a narrow terms of reference inquiry? Was the decision in the Letby case a logical decision? Is there an element of doubt? Was it proven beyond a reasonable doubt? Was there manipulation, confusion of the jury with some of the evidence? And it's not just my word, it's people who sat through the case. We look at their transcripts and they are available. Some people have got audio transcripts and they've made those available. We can look through all the evidence and it seems to be magical realism or magical legalism, which is just convincing through overload in a way. So if you find it interesting, want to comment, either way, I very much welcome debate.